Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the I-601 waiver. Specifically, we're discussing pregnancy of the waiver applicant. Usually when I deal with I-601s, mostly our practice within immigration is in a family context. So we're dealing with 601s in the context of, for example, a K-1 fiance visa, a K-3 marriage visa, a CR-1 marriage visa, or an IR-1 marriage visa. In all of those contexts where an I-601 is necessary, we're dealing with an underlying family-based case. Pregnancy can come up because you have, in these cases, we're presuming an American male and a foreign female. That foreign female can become pregnant or give birth to a child during the processing of a given visa application. This is especially the case where you're dealing with a later I-601 adjudication, because that later adjudication will add time on to the overall processing time of that given case. And the question that I've had come up over the years is, well, how does a pregnancy impact the I-601? Well, it depends. I don't mean to be purposely vague in this video, and I actually really kind of batted it back and forth whether or not to even make this video, but I did think it was rather pertinent, and it does come up rather, not frequently, but it does come up from time to time when an I-601 is processing, that a pregnancy happens or a child may come about during the processing of that 601 waiver application. The thing to take away from this video, though, is it's going to be circumstantially dependent, so I don't want anything to be taken hereafter as set in stone with respect to all cases. The child may or may not actually be directly involved in the analysis of whether or not a waiver should be approved. In many cases, the existence of a child, a U.S. citizen child specifically, born to the foreign national who is being adjudicated for the 601, oftentimes the existence of that child only factors into the adjudication in sort of a tangential manner. It's not really directly pertinent to that analysis. But that being said, there are multiple ways in which an I-601 waiver can be issued under multiple different aspects of the Immigration and Nationality Act. So again, circumstances vary, and that pregnancy or that child being in existence, it's going to depend on the specific sections and the specific legal ground of inadmissibility. But for the most part, their existence is only going to impact the adjudication, as I said, in sort of a tangential manner. But as I've said in other videos with respect to pregnancy and the visa process, it's almost commonsensical. It doesn't hurt the case by any stretch of the imagination. Yes, it may change things with respect to financial considerations, especially in the context of a 601, that may or may not be beneficial to the applicant in the adjudication process. It may have an impact, again, tangentially in terms of sort of the familial relationship with all parties concerned and the qualifying relatives associated therewith. But that being said, the thing to take away from this is it's really a pretty good idea if this is a major issue and you're looking at a 601, contact a legal professional, get some insight into this, because 601s are a complicated matter. They're becoming even more complicated in light of the recent changes to USCIS policy regarding requests for evidence, etc. So the thing to take away from this video is contact a legal professional under those circumstances in order to get better insight with respect to exactly how a pregnancy impacts the 601 process. But again, there's certain commonsensical aspects, and I hope that some of the information provided in this video has at least guided folks in a direction to be able to sort of find their way, preferably to somebody who deals with these matters on a regular basis, in order to navigate their family into the most advantageous situation possible within our immigration system.